Right now, in most of America, marijuana is two things at the same time. It is completely legal under your state's law, and it is a federal crime, not used to be. Right now, the exact same joint can be perfectly legal to the state trooper and a federal offense to the agent standing next to him. So, how is that even possible? How can something be legal and illegal in the same place on the same day? The answer isn't really about weed at all. It's about who gets to boss around the states. Here's what almost everyone assumes, that when a state legalizes marijuana, it overrules the federal ban. It doesn't. It can't. No state can pass a law that erases the federal ban. That ban still applies in all 50 states. Picture two separate rulebooks stacked on the same table. One federal, one state. Legalization doesn't erase the federal rulebook. It just changes what's written in the states. And it turns out those two books are allowed to disagree. To see why, you need two rules of the Constitution. They pull in opposite directions, and the gap between them is where legal weed lives. Rule 1 is the tough one for anyone who wants marijuana legal. The federal government absolutely has the power to ban it. Everywhere. Even the plant in your own backyard. And we know that for certain because of one woman who took that exact fight to the Supreme Court and lost. Meet Angel Raich in California in the early 2000s. She was seriously ill, and her doctor said marijuana was the one thing keeping her functional, that without it, she could waste away. California law allowed it. Raich was too sick to grow it herself, so two caregivers grew it for her and gave it to her free. Marijuana that was never bought, never sold, and never left the state. Her co-plaintiff in the same lawsuit, Diane Monson, did grow her own, just 6 plants for her chronic pain. Federal agents came to Monson's home, and over the objection of local officials who said it was legal under state law, they seized all 6 plants and destroyed them. So, Raich sued the federal government. Her argument was simple and, honestly, intuitive. This marijuana, she said, never entered the marketplace. It wasn't commerce. It didn't cross a single state line. So, where does Washington get the power to reach into my home and ban it? The government's power to make that ban comes from one line in the Constitution, the Commerce Clause. Now, growing your own plant for yourself sure doesn't sound like trade among the states. So, how does it count? Through a move the court made decades earlier, in a case about a farmer named Filburn who grew extra wheat to use on his own farm. The court said, sure, your little bit doesn't matter, but add up every farmer doing the same thing, and together it moves the national wheat market. So Congress can regulate even your private patch. It's the grain of sand logic. One grain is nothing, but the whole beach is something Congress can touch. So in 2005, in Gonzales versus Raich, the court applied that same logic to marijuana. 6 justices to 3, Raich lost. The reasoning, homegrown marijuana is part of a giant national market, most of it illegal. And if the government couldn't regulate the homegrown kind, that whole market would be impossible to control. So, even your personal, never-sold plant is fair game. Bottom line, and this is settled law, the federal government has the power to criminalize marijuana anywhere in the country. Full stop. But 3 justices were alarmed, and one dissent is worth remembering. Justice Clarence Thomas warned, in effect, that if the government can regulate a plant you grow in your own yard, never sell, and never move across a state line, then it can regulate almost anything. And the idea of a federal government with only limited listed powers starts to disappear. Hold on to that discomfort, because years later, Thomas would look at what the government actually did with this power and call the whole thing a contradiction. We'll get there. So, where is the ban written? In a 1970 law called the Controlled Substances Act. It sorts drugs into 5 buckets, called schedules. Schedule 1 is the most restrictive, the bucket for what the government treats as the most dangerous drugs, the ones it says have a high potential for abuse and, in the law's words, no currently accepted medical use. And marijuana has sat in Schedule 1, next to heroin, since 1970. On paper, in the eyes of federal law, it's treated as one of the most dangerous substances there is. So, let's take stock. The feds have the power to ban it. They use that power. Marijuana is federally illegal, coast to coast, treated like heroin, which makes the real question sharper, not simpler. If all of that is true, Then how on earth is there a legal dispensary a 10-minute drive from where you're sitting? The answer is Rule 2, and Rule 2 is the twist. Here's the second rule of the Constitution, the one that flips everything. The federal government can pass its own laws, but it cannot force a state government to enforce them. Washington can't turn state legislators and state police into its personal enforcement squad. Lawyers call it anti-commandeering. In plain English, the feds can't draft the states into doing their dirty work. The feds have to enforce federal law with their own agents, on their own dime. This isn't some loophole a clever lawyer found. The Supreme Court has said it firmly, more than once. In one case, it struck down a law forcing states to deal with radioactive waste Congress's way. In another, a gun law case, it struck down a rule ordering local sheriffs to run federal background checks. The through line: think of the states and the federal government as separate sovereigns. One can't hand the other a to-do list. The feds can ask, they can bribe with funding, but they can't command. And then, in 2018, the court took it one crucial step further. In a case that, believe it or not, was about sports betting. A federal law had banned states from allowing sports gambling. New Jersey wanted to repeal its own ban, and the court said the feds couldn't stop it. Because forcing a state to keep a prohibition on its own books is just commandeering by another name. That case, Murphy versus NCAA, is the key that unlocks marijuana, not because it was about weed, it wasn't, but because of its logic. Washington can't force a state to keep any particular law on its books. Apply that same logic to marijuana, and a state is just as free to repeal its own weed ban. So, watch exactly what a state does when it legalizes. It does not repeal the federal ban. It can't touch that. What it does is erase its own state marijuana crime and tell its own police to stand down. It's the difference between tearing up someone else's rulebook and simply putting down your own pen. The state isn't overruling Washington. It's just refusing to be Washington's enforcer. Now, you might be thinking, hang on, doesn't federal law win when the two conflict? Usually yes. That's a rule called preemption. But there's no conflict here, and this is the subtle part. A conflict would mean you literally can't obey both laws at once. But a state simply choosing not to punish something the feds punish, you can comply with both. The feds are free to enforce their ban, and the state is free to sit it out. And so far, every court that's looked at it has agreed. No collision, no preemption. So here's where we've landed. Federal law still bans marijuana everywhere, and it's still completely valid. Federal agents could, in theory, walk into any state legal dispensary and start making arrests. They mostly don't. And that's the part people mistake for legality. It isn't legality, it's a choice. A decision by the federal government about where to point its limited resources. And choices can change. For years, that choice was written down. The Justice Department issued a memo telling federal prosecutors to basically leave state-compliant marijuana alone and focus on the real problems: cartels, sales to kids, guns. But a memo is not a law. In 2018, a new attorney general tore that memo up. And here's the telling part. Even then, there was no great crackdown. The hands-off approach mostly held, because it was never really about the paper. It was about priorities. Congress added one more layer, and it's a sneaky one. Every year, it quietly attaches a line to the federal budget that says, the Justice Department may not spend a single dollar interfering with state medical marijuana programs. It's a leash made of money. Congress didn't legalize anything. It just refused to fund the enforcement. But note the fine print. It only covers medical marijuana, not recreational, and it has to be renewed every single year, or it vanishes. So, step back and look at the whole strange machine. Federally illegal, state legal. Feds allowed to enforce, but choosing not to, partly because Congress won't pay them to. Even a Supreme Court justice noticed how tangled this had become. In 2021, Justice Thomas, the same justice from that Raich dissent, called the federal government's approach a half-in, half-out regime, one that, in effect, tolerates and forbids marijuana at the very same time. But here's the important part. That wasn't a ruling. It was a solo statement he wrote the moment the court decided not to even hear a related case. Thomas thinking out loud, not the law changing. Raich still stood, And then, in 2025 and 2026, it got even stranger. For decades, the fight was over one question. Should marijuana move out of Schedule 1, that as dangerous as heroin bucket? In late 2025, the president ordered the process sped up. And in 2026, the government finally acted. But it didn't do the simple thing everyone expected. It did something almost no one saw coming. It split marijuana in two. Here's what happened, and it's genuinely bizarre. As of 2026, the government moved medical marijuana, the kind sold under a state medical license, down to a looser category, Schedule 3. But it left recreational marijuana right where it was, in Schedule 1. So, the exact same plant now lives in two different legal boxes at once. Schedule 3 if it's sold through a state medical license, Schedule 1 if it isn't. If the half-in, half-out regime sounded confusing before, the government just made it more literal. Now, be careful here, because this is easy to overhype. Moving medical marijuana to Schedule 3 does not make it federally legal. It's still a controlled substance. Recreational marijuana wasn't touched at all. Still, Schedule 1, still a federal crime, even where a state allows it. What the change mainly does is loosen research restrictions and hand medical businesses a big tax break they were denied before. And even this split isn't the final word. As of 2026, a separate government process is still grinding through whether to move the rest of marijuana, the recreational kind, down as well. It hasn't been decided. On top of that, the split itself is being challenged in federal court and could be undone. So, if you're watching this and wondering what the exact rules are today, check the description because this specific piece is moving fast. And honestly, that uncertainty is the whole point of the story. Here's the most concrete way that federally illegal bites, even in a legal state. The banks. A marijuana business, fully legal under state law, often can't get a normal bank account. Why? Because banks answer to federal regulators, and under a 1970 law called the Bank Secrecy Act, they're required to watch for money tied to federally illegal activity. And marijuana money is, by federal definition, exactly that. So many banks just say no, which leaves legal, tax-paying marijuana businesses running on cash, piles of it. Cash for payroll, cash for rent, cash to literally carry to a government office to pay taxes. That makes them magnets for robbery. It's the strange side of a business that's legal enough to tax, but too illegal to bank. And notice where this connects. Banks became the government's financial watchdogs through that same 1970 law, and a Supreme Court case that said, your bank records aren't really private. The moment weed touches the banking system, it runs straight into all of that. Congress has tried to patch this for years with a bill usually called the Safe Banking Act. It would shield banks that serve state legal cannabis businesses from federal punishment. It has passed the House of Representatives several times. But as of 2026, it has never passed the full Senate and never become law. It was introduced yet again in 2026, and it's still stuck. So, for now, the cash problem remains. So, should the federal government keep marijuana illegal while states go their own way? Honest people land in very different places. And this video isn't here to pick for you. Both sides are arguing about the same real tension, and the courts have left a lot of it unresolved. Here's the part that surprises people most. The rule that lets states defy Washington on marijuana is the same rule behind fights all across the political map. It's why sports betting spread after 2018. It's why some cities refuse to help enforce federal immigration law. It's why some states won't enforce certain federal gun rules. Anti-commandeering doesn't care if you're on the left or the right. It's a structural feature of American federalism. And just about everyone reaches for it when Washington tells their state what to do. So, is this contradiction forever? Not necessarily. The pieces have an arc, and it's still being drawn. Congress could legalize or fully reschedule any time it chose. The Supreme Court could revisit Raich. Remember, a sitting justice already thinks the current setup makes no sense, or the standoff could simply continue. So, the next time you hear that a state legalized marijuana, you'll know the fuller truth. It's still a federal crime, everywhere, and what really changed is that the state stopped being Washington's enforcer, something the Constitution says it's free to do. Legal and illegal at the same time, in the same place. Not a glitch, a feature of how power is split in this country. Whether that half-in, half-out system is a mess that needs fixing or federalism working exactly as designed. That part, you get to decide. Now you know.